once again to my channel. My name once again is Alex, and basically today we want to talk about mortgages, the law regarding mortgages, the law governing mortgages, creation of mortgages, and basically what are the remedies available in case there is breach of a covenant created under mortgages, in case there is breach of a mortgage agreement. What are the remedies available? Basically, so what is a mortgage? A mortgage is actually defined under Section 1 of Mortgage Act. The definition is there, and also it was defined in the case of Chandler versus it's actually the case of Chandler. It also basically, but the general outlook of it is that a mortgage is where a person gives out his property or his land as a security for securing a loan, and that is basically what a mortgage is, and it is the legal conveyance. That's basically what it is: a legal conveyance of land for purposes of securing a loan. And when you look at Section 1 of Mortgage Act, it basically means that a mortgage includes a charge. It includes a charge, a lien, or a lien over land, or an estate, or interest in land, or in land in Uganda, which is given out or which is conveyed to some other person for purposes of securing a loan. Look at Section 1 of Mortgage Act. You will appreciate it the more. Of course, I have to also interest you in a landmark decision, which also defines a mortgage. That is the Chandler versus Wilde. Chandler versus Wilde defines a mortgage as conveyance of land or interest in the property for purposes of securing a loan. Let's now look at the creation of a mortgage. How is a mortgage created, and on which land or on which property or under which land, under which type of tenure can we have a mortgage created? A mortgage is basically created on every land, on any land held under any type of tenure. That's basically when you look at Section 2, subsection 1, it provides for creation of a mortgage, and it is basically the effect that any person who holds the land under any form of tenure has the right to mortgage his or her property or his or her land. Let me read it verbatim. It provides that is Section 1, subsection 1, provides that a person holding land under any form of land tenure may, by any instrument in any prescribed form, mortgage his or her interest in land or part of it to secure the payment of a loan. That's basically what it is. That means that whether you own land under customary tenure, whether you own land under leasehold, or you own land under freehold, you're free to mortgage that property. Okay, that is very important for us to appreciate. Specifically Section 2, subsection 1. When you look at this section, it talks about a prescribed instrument. Of course, for purposes of that instrument, you have to look at schedules. You will get it more. And another important thing that you need to appreciate here is that a mortgage only takes effect upon registration. Therefore, if it is not registered, my brother, my sister, that mortgage will not take effect. However, it can only take effect as an equitable mortgage. We shall later talk about different types of mortgages, but for purposes of having an effective mortgage, it has to be registered. Okay, that is very, very important for purposes of ensuring that a mortgage is registered and takes effect as a registered mortgage. Please look at Section 2, subsection 4 of Mortgage Act Please note, Mortgage Act is Cap 239 as per the revised volumes or revised version. Okay, let's look at different types of mortgages. Mortgages, they are divided into two categories. Number one is what we call a legal mortgage. And a legal mortgage is that one mortgage that is created under the Mortgage Act. That is what we call a legal mortgage. And then another type of mortgage is what we call equitable mortgage. Equitable mortgage, this is the type of mortgage that is recognized under the doctrines or principles of equity, whereby basically this is where you find that a person had an intention of creating a mortgage, but because maybe he drafted an instrument but did not conclude or did not finally register that instrument, that suffices only as an equitable mortgage, because as you know, basically equity, I know when if you have appreciated the equity, these are basically principles which were recognized under the courts of equity. Okay, so where an instrument is not registered, and but the person that drafted it, or this person had an intention to create a mortgage, but it was not registered, then that means it only suffices as an equitable mortgage. Okay, that is very, very important. Please, for purposes of creation of an equitable mortgage, you need to know that where an instrument, as I earlier mentioned, where a person deposits instruments to the registry, but the registration is not completed. Okay, the registration is not completed. Oh, of course, you deposit a title, but maybe that title is not accompanied by a memorandum. Actually, that is the best example. You deposit a title, but that title is not accompanied by a memorandum. That only suffices as an equitable mortgage. As a reminder, a legal mortgage is that type of a mortgage that is created under the Mortgage Act. For example, you deposit a title, you accompany it with a memorandum, you register it at the registry. Of course, here it takes us back to what we call encumbrance. You register it as an encumbrance on a title. Then it takes effect under section 2, subsection 4. That becomes a legal mortgage. Okay, that is very, very important. As of course, for purposes of clarity and emphasis, under the law of mortgage, we have basically two important persons. Number one, we have what we call the mortgagor. Number two, we have what we call the mortgagee. A mortgagor is that person that gives out his land or his property, or that person that he intends to create a mortgage, or that person that intends to secure a loan. That is the holder of the title, who conveys his property to another person for purposes of securing a loan. That is very, very important for us to appreciate. Then a mortgagee. A mortgagee is that person, in a local sense, I would call that person that has money, that wants to give it this other person, that person that wants to give out a loan to another person. So that is the person that will receive a title from the mortgagor. That is important for us to appreciate. So the two persons, it is better that you understand them. Of course, for purposes of those definitions, please appreciate section 1 of Mortgage Act. You will get to understand different persons. Now there is always a question as to whether it is possible to create a mortgage on a land that is held under customary or under customary tenure basically. That is a question that needs us to understand and answer correctly. Of course, it is a question that everyone must understand. What you need to know, as I earlier mentioned, Section 2, subsection 1 gives the person a right to create a mortgage on any type of land, on any land held under any type of tenure. Okay? So that means when we talk of any type of land tenure, that means we are not leaving out customary land. We are not leaving out customary tenure. Please, these different types of tenures are provided for under the 1995 Constitution. Look at Article 237, Clause 1 and Clause 3. It provides for all the tenure systems, be it customary, be it leasehold, be it freehold, be it whatever type of land tenure. Please check it out. You will appreciate more. They are also provided for under Section 2 of Land Act. They are also given definitions and they highlighted and given the structure under Section 3 of the Land Act. Please check it out. You will appreciate the more. Let's move on, and you will need to look at, there is a very important decision that I would love us to appreciate. When you look at the case of Mutamblile versus Chimera, it's a case of 1975, a High Court bulletin at page 150. You will understand that for this case, the jurisprudence here is bringing us the fact that when one creates a mortgage under a customary land, the law applicable here is the customary law, not customary law, is the law of equity and common law. As you appreciate very well, you know what common law means. Look at Judicature Act. Section 14. Judicature Act provides for, Section 14 actually provides for common law and doctrines of equity. Look at it, you will appreciate it the more. So, Mutambrile versus Chimera brings it out very well that where a mortgage is created on a customary land, then the law applicable here shall be the doctrines of equity and common law. That is very, very important for us to appreciate. Okay? One more thing that you need to appreciate the more here is that a mortgage only takes effect, or it takes effect as a security, and it does not pass interest in the land. That is what we call doctrine of redemption, or redemption of a mortgage. So in short, when you look at Section 7 of a Mortgage Act, it brings it out very well that a mortgage only takes effect as security. I want to read it in verbatim so that we don't miss out any point. Section 7, it brings it out very, very well. That a mortgage only takes effect as a security, not and it does not pass interest in the property. Okay, so look it up and appreciate it very well. It's a very long provision, but of course you need to look at it and appreciate it very, very well. It provides that's subsection 1. Actually, Section 70 provides that mortgage of land takes effect as security only. That is important. Don't miss out on this. Therefore, at any point in time, I repeat, at any point in time, the mortgagor will have the right to redeem his property back. In case he pays back the loan, if he pays back the money owed, then he will be able to recover his property. That's what we call the doctrine of redemption. It means the mortgagee has no right to sell that property when he has no right of sale. He has no right to take up that property. In short, he has no, the mortgage does not pass any interest, does not give interest in the property, does not give the mortgagor interest in the property. And the provision is the effect that on and after the commencement of this act, a mortgage shall have effect as security on and shall not operate as a transfer of any interest or right in the land from the mortgagor to the mortgagee. But the mortgagee shall have, subject to this act, all the powers and remedies in case of default. Okay? I know we shall have another video which we shall basically be regarding the remedies available to the mortgagee, to the mortgagor or the mortgagee, depending on the circumstance. So the provision is to the effect that it only passes as a security and not it does not pass any interest in this property. Therefore, it only passes as a security. Okay, that is very, very important. Look at the decision of Mutambulire versus Chimera, the case of 1975, High Court Breton, at page 150. It will bring it out very, very, very well. Please, for purposes of understanding the law regarding mortgages, read Mortgage Act. Mortgage Act brings it out very well. You will understand it very well when you read the act verbatim. Take your time, read it. Let's have watch out. There is another video on remedies available for the mortgagee or for the mortgagor. Check it out. The video is there. We meet in another video. Please take time, subscribe, share with your friends. Let's embrace the art of learning together. It is very, very important. Law school is that kind of a section where you cannot learn alone. Let's learn together, subscribe, and share with friends. God bless you.